Would you ask Miss Upton to come back in, please?
Thank you.
All right, Miss Upton, ready to carry on?
Yes, thank you.
Thank you very much. Yes, Miss Skinner.
Thanks, sir. Miss Upton, the next topic I'd like to discuss with you is the London Assembly report on tall and timber-framed buildings, which was published in December 2010. Now, the report was prepared by the London Assembly's Planning and Housing Committee, and to give its full title, it was entitled Fire Safety in London, Fire Risks in London's Tall and Timber-Framed Buildings. A copy of the report and the recommendations was sent to the Fire Minister. The report can be found at INQ 0014711. If we could turn to page 11 in this document, hopefully we'll find the executive summary. And we see in the second and third paragraphs on that page the relevant background, which is as follows. In January 2010, the London Assembly called for an inquiry into the fire safety of London's tall and timber-framed buildings. It was prompted by a series of fires that included the fatal Lacknell House blaze in July 2009 that cost 6 lives. This inquiry was commissioned specifically to look into issues around fire safety in London's residential buildings, with a particular focus on timber-frame structures and tall buildings, and to make recommendations to the Mayor of London and Her Majesty's Government with regard to building regulations. Now, if we can go directly to the recommendations, which are at page 41. And if we look at recommendation 7, which is at the top end of this page, it said this. By 2012, DCLG, in association with relevant bodies such as the Local Authorities Coordinators of Regulatory Services, LACORS, and Chief Fire Officers Association, should draw up national guidance to ensure mandatory minimum standards of competence for training and accrediting fire risk assessors. At the time, so December 2010, what was your response to that recommendation?
I can't remember. I imagine we would have said that we were working with the sector to develop standards of competency.
Now, if we, in your statement you mentioned that you coordinated the proposed departmental response and provided the Minister with advice on the actions being taken to address the recommendations and proposed an official reply to the scrutiny manager at the London Assembly. Now, we have a copy of the draft reply you proposed to Mr Neil, then Fire Minister, at HOM 000-46072. And if we go to the second page and look at the fourth paragraph, it says this. We have no plans to introduce a mandatory minimum standard of competence for training and accrediting fire risk assessors, but we very much welcome the fire sector's decision to lead the work to develop and agree criteria against which to assess the competency of those offering risk assessment services. Can you help us at all? Was the letter sent as drafted here? Can you remember?
No, I can't remember.
Did you advise the Minister that the assertion... Sorry, you...
Sorry, is this the letter that was sent?
No, this is the draft, we think.
Oh, right.
Hence why I asked you, was
Yes.
it sent in this form, finally?
I'm not sure. I haven't. I think the final form of the letter was in my bundle.
Okay. Well, can we look at what you've said here?
Yeah.
When you said we have no plans to introduce a mandatory minimum standard of competence for training and accrediting fire risk assessors, did you advise the Minister that that was, put neutrally, a departure from what had been agreed in December 2009?
I don't expect so.
Why not?
Yes, just because of the question. I suppose I can't remember what I've read, but I suspect you've asked the question because I didn't. So I don't know. I'd need to look at the advice that we put to ministers.
Well, looking at matters slightly differently, did you advise the Minister to consider whether the approach you set out here, i.e. you have no plans to introduce the mandatory national standard, remained appropriate given the concerns that were set out in this report and which were summarised in the executive summary?
No, we didn't. I don't believe we ever put a question to ministers, should there be a mandatory minimum standard of conduct. I don't believe we ever did that.
Given its importance and prominence in the discussions you were having with the sector, why didn't you put that to relevant ministers?
I suppose in the interest of keeping things short, saying what we were doing, expediency, I expect.
When you say expediency, what is that a euphemism for? Is it that you didn't want to put this before the Minister because you didn't want an answer you didn't want or like?
Yeah, I'm not sure. I think we recognised in the fire safety unit, we would have had discussions with with my manager around the advice that we put to ministers. I think we kind of just understood the direction of the policy direction around regulation. So I think we just made assumptions that there would be little appetite for this without, I suppose, actual evidence and the resource to pull together evidence and consider it was something that we didn't have at the time within my unit.
But a number of points arise from that. First of all, as we established before the lunch break, you didn't, for example, ask business about their views about what was needed to address what appear to be fairly long-standing concerns about the competency of fire risk assessors. That's right, isn't it?
In terms, but we would have had views from business. It was a range of views because we were talking to them all, I suppose, a lot.
Well, the transcript...
We didn't yes.
The transcript of what you said before lunch stands, obviously, but can we maybe look at it slightly differently? At the start of your evidence today, you said you'd put matters that were significant before the Minister for information or indeed decision. Given the nature of the concerns arising out of fire risk assessor competency, why were those concerns not sufficiently significant for you to put these matters and advise the Minister fully about what the options were?
I don't have a good answer for that, I'm afraid.
Or do you have any answer to
No.
that? You just didn't?
We just didn't know. We just didn't.
Can I now turn on to the Fire Futures Review and Fire Futures National Interest Workstream Report, which was also published in December 2010. And we can find that at FSF 0000037. Now, is it right that the Fire Futures Review was launched by Bob Neal MP in July 2010 when he was or became the Fire Minister?
Yes, I believe so.
Can you remember now, what was the purpose in establishing the National Interests Workstream?
No, I'm afraid I can't remember. I wasn't very close to this work. I fed in, but it was led by others in the unit.
Who or which department within DCLG commissioned this report from the National Interest Workstream?
I think this was the team that was led by Dawn Eastmead. And I think at the time I was still in a different team led by Sandy Bishop.
Now, mindful of that, could I just nonetheless go to some recommendations made in the report? Could we go to page 10? And if we can look at the beginning of the second paragraph in the left-hand column, it said this: the built environment continues to become more complex and the threat of fire more difficult to counter. We have found that there is significant evidence that fire safety is currently lagging behind these changes and needs to catch up. Otherwise, there is a major risk that fire safety problems are simply inadvertently created and locked up in the built environment to cause problems for fire safety in the future. Did you agree with that view in December 2010?
I'm not sure. I don't think we had the evidence from the data of fires. I mean, I could see it was a risk, but I don't know what evidence they were talking about when they say there was significant evidence it was lagging behind changes.
Did you have any reason to doubt the accuracy or the reasonableness of that conclusion, that there was significant evidence that fire safety is currently lagging behind these changes?
I'm not sure I can answer that. I think I'm not sure I had a view. I would have liked to have seen the evidence.
Do you remember contacting the colleagues in the department who are responsible for this document to ask what was the evidential basis for the conclusion that fire safety was lagging behind?
No.
If you had had substantive concerns, would you have made contact with the relevant policy officials to raise that point?
Yes, I imagine I would.
Could we look at the start of the fourth paragraph in the left-hand column? It says this: there is currently a perceived low level of competency within the sector in relation to fire safety and built environment, not helped by the fact there is no common qualifications framework that covers building and fire safety competencies. Did you understand the phrase fire safety competencies also to include fire risk assessors?
Yes, probably.
That conclusion is substantially the same as that reached by the initial valuation report and Sir Ken's final report following Lacknell, isn't it?
Yeah.
Could we look at the penultimate paragraph in the right-hand column, which says this: there is undoubtedly an important role for industry-endorsed third-party certification schemes, but the schemes must themselves be fit for stated purpose and properly accredited. The optimum effect will only be achieved by officially mandating third-party independent schemes or by receiving much wider specifier and client endorsement by insisting on third-party schemes to mitigate risks by specification. Now, this report appears to be calling for industry-endorsed third-party certification schemes for fire risk assessors. Would you accept that?
Yes.
To your mind, did the observation that the optimum effect will only be achieved by officially mandating third-party independent schemes require a sanction from a body such as UCAS, or alternatively, the department itself?
Yes, I understood it to be officially mandating to mean the department itself.
Did you think that officially mandating third-party schemes at this time was necessary and desirable?
No.
Can you help us as to why?
Because I thought the process we were engaged in should run out. I didn't think we'd had enough evidence to conclude that it wasn't going to deliver something of value.
Can you help us? You've referred in a number of answers to not having enough evidence. We're now December 2010. We've been going through a series of reports that have been published since March 2009, all of which are characterised by consistent reports of concerns regarding fire risk assessor competency. What was the scale of the critical mass of evidence that you were looking for that would persuade you that an officially mandated third-party independent scheme was necessary and desirable?
I don't know. I think is the answer. Probably a collected view from fire and rescue services, perhaps based on enforcement action that they'd taken, or yes, I don't know. It was kind of bobbing up every now and again, and it wasn't it kind of didn't have the critical mass of issues. Lots of things didn't in fire safety, but it was kind of, there was action underway to deal with it. It was the same concern coming up, but it was kind of being worked through.
Well, we have two reports, both dated December 2010. Did you discuss the recommendation for an officially mandated third-party scheme with the Minister, given what you'd recommended on the back of the tall and timber-framed buildings report?
I didn't know.
To your knowledge, did anyone?
I don't know whether anyone did.
You say these issues were bobbing up. What we've been going through today is a series of reports in a 20-month period between March 2009 and December 2010. Would you agree with me that the theme emerging through all of those reports is clear and consistent, that there were reservations, put mildly, about the competence of fire risk assessors in England?
Yes.
And equally consistently, there were calls for an officially mandated system supported by independent accreditation, UCAS or something else. That line of concern was loud, clear and consistent. Would you agree with that?
Yeah.
Then why did you hold to the view that an officially mandated scheme wasn't necessary?
I suppose, as I said, because we had started this work, it hadn't concluded. We weren't in the business. The minister, I suppose the environment was, we just knew it would be unwelcome by business and ministers. But we didn't test it. You're right. It was I made assumptions
that weren't sound.
That weren't sound.
Could we turn to page 11? And here is set out, you'll see a number of recommendations. And the first recommendation you'll see on the left-hand side is this: there is no need for further legislation. However, the sector should lead on the application of knowledge linked to competency, certification, data sharing and awareness programs. The government should endorse this process and ask that part of the sector for a formal plan of action. Did that reflect your considered position in any way?
Yes, I think so. We didn't ask for a plan of action, which we should have, obviously.
Do you know why a plan of action wasn't sought? No.
No.
On the 7th of February 2011, you prepared a submission to the Minister, Bob Neal, which we can find at HOM quadruple 01003. Now, we can look at paragraphs 8 to 13, which are on the second page of the submission, where you set out various considerations. Could I ask you to read those paragraphs to yourself, and if you could indicate when you need the document manager to turn the page and when you've finished.
I'm ready.
Why does the submission of February 2011 not note that the Fire Futures report had recommended mandatory third-party accreditation to the Minister in December 2010?
I don't know. Maybe I'd forgotten.
Could we go to page 3 and stay on that page and look at paragraph 11? And it said this: we propose to offer continued support and potential barrier-busting resource to the sector to effectively resolve any concerns that the existing certification bodies, including the professional institutions, may have over applying for UCAS accreditation, and develop consensus as to the future basis of any scheme or schemes. What did you mean by the phrase potential barrier-busting resource?
I suppose if they encountered a problem, it was really saying we'll engage if they want us to engage on an issue that they can't sort out for themselves, I think.
What form would, quotes, continued support, close quotes, take?
Attending meetings, being available to talk to them, not very much really, not other than keeping a watching brief over the progress being made, probably.
Now, as you say, that's not very much.
No.
How is that continued support, as you called it, how is that going to address the problems that have been identified regarding fire risk assessor competency?
Well, essentially, we were hoping that they were aware of the concerns, and our hope and aspiration was that they would address the concerns and we would support them to do that.
This is February 2011. The first meeting of the FRAC Council was in December 2009. Industry hadn't met the hopes that you'd set for them, had they?
No, but I think they were still working on it at this stage.
But can you explain, because one of the difficulties arising out of your evidence, Miss Upton, is quite why you were extending continued hope to them, absent much meaningful development or work coming from them?
Yeah, I don't have a good answer apart from the policy environment was very much hands off. We were stepping back. We didn't have the resource. If there was a problem, we expected, and ministers expected, the sector, and the Fire Futures was very much around people using their influence to deliver the change that was needed. It was a very clear. Government is.
You say we didn't have the resource, yet you offered the prospect of, quotes, potential barrier-busting resource. On what basis did you advise the Minister that what appeared to be significant additional resources, on what basis they were available?
Well, I think that was really, that was a way of saying we would pull people in if they couldn't agree and bang heads together, possibly.
Barrier busting suggests money rather than personnel, doesn't it?
Oh no, I don't think so. Actually, I don't think there was any money. I'm not sure there was money. I genuinely think that was a people resource rather than a financial resource.
Would it have been helpful to the Minister to have said, I put this bluntly, you were chucking more people at the problem as opposed to it chucking more money at the problem?
Yes. Well, I suppose so, but the environment when this was written, there was very little money around.
Now, could we look at paragraph 12? And I'll read it out so people watching know what I'm referring to. You said this. Without our continued engagement, there is a risk that the sector, which remains relatively fragile, would stall on its work to develop one or more national registers of competent risk assessors. This would perpetuate the difficulty responsible persons already face in identifying, with any degree of confidence, the competency of those offering risk assessor services, and may lead to accusations from the business sector that the government has not done enough to ensure the responsible persons are readily able to identify suitable support to deliver a sufficient level of fire safety on their premises. In addition, having initially facilitated bringing the sector together to lead this work, the FRAC may perceive any scaling back of DCLG engagement as a withdrawal of support to the sector in professionalising the risk assessor market. At the time, did you think there was a likelihood, probability, that the sector would, quotes, stall on its own work, close quotes?
Yes, I think so. It was a risk.
Did you think there was an appreciable risk, if I can put it like that the sector, even if willing, would be unable to bring about the required changes to assuring fire safe risk assessor competency?
I'm not sure. I think I had an optimism bias eventually, but it wouldn't be quick.
Were there any benefits looked at differently? Were there any benefits to scaling back the department's involvement?
No, it was very minimal anyway, our involvement. I'm not sure, we were really just saying we would maintain the presence and support as required.
Because withdrawal of the department, such minimal benefits as may accrue, were unlikely to outweigh the risks. Would you agree with that?
Well, I think we probably would have had levers that we could have used ultimately.
Such as?
Well, having, discussing it, fleshing out the problems at a more senior level than mine with my managers and with ministers, and coming up with a more considered plan potentially.
So further discussions rather than substantive policy intervention in the forms of regulation or whatever.
Yes, but I suppose those more other discussions might not have precluded the introduction of regulation or.
Could we now turn to a separate topic, which is your involvement with the Competency Council? Am I right in saying that you attended most FRAC meetings until April 2011?
Yes.
Why did you attend them?
To kind of to try to understand what was going on within a difficult discussions, to make sure that that it was staying on track, really, that there were serious discussions going on around what a competency standard might look like, that there was that sense of ownership, and that there was a process in place to get to a point at which we could then take it further potentially.
Did you attend the enforcement work stream of the FSF's work? Excuse me.
The working group, the enforcement working group, you're made up of fire safety officers. Yes, I did.
Would you routinely brief colleagues from the department following these meetings, whether informally or otherwise?
Yes.
Could we go to CLG 000 35510? And if we look at the foot of this first page, there's an email from Anthony Maud, who was one of your colleagues in the department, to you and other officials, which was sent on the 6th of May 2011. Now, the substantive email is at the top of page 2, if we can go to. Thank you. Where he says, I attended the second meeting of the Fire Sector Partnership last month. They've changed the name from Fire Community Partnership. List of members attached, neither CFIR or the LGA attended. Partnership are mainly concentrating on setting up working groups to take activity forward. They then set them out. Naturally, matters are at an early stage, mainly concentrating on scoping, but there did seem to be some energy amongst the group. Brian Robinson is keen to get DCLG observers on the working groups as participating observers. As you know, he sees the sector very much in the lead, but clearly there are issues where we can offer some input into the deliberations, not least an in-depth knowledge of where matters currently stand. I think this fits in with the department's approach of not leading, but seeking to contribute and influence where necessary. Would you be content for the chairs of work groups to contact named individuals here regarding involvement? Did you think getting involved in the way commended by Mr. Maud was a worthwhile endeavour?
Yes.
Did you think that the recommended approach was consistent with the department's approach of not leading?
Yes.
Could we turn now to another chain of email correspondence, and particularly an email sent by Brian Martin on the 9th of August 2011, which can be found at CLG 1004866/5. And if we could look at the bottom of that page. Here we can see that Brian Martin asked for your advice on an extract from the draft minutes of a meeting of the Fire Sector Partnerships Technical Standards Committee, which had been held in July 2011. We can see that he includes there the following excerpt from the draft meeting report, and he says this: DS, who we understand to be Dave Sibbott, said that any organisation has always had the right to produce its own guidance concerning fire safety in the built environment. But from somewhere, there has to come a single minimum standard, if it draws on other sources, that should be applied in order to claim that good practice has been used to deliver a reasonable standard of life safety. Historically, that minimum standard has normally been described within government publications or publications endorsed by government. However, government has stepped back from this role and intends to leave it up to the sector. Now, Brian Martin then continues, it's in the blue text: it would be helpful if we could clarify exactly what the department's line is on the government stepping back. As far as building regulations are concerned, there are no plans at present to withdraw approved documents. Has any such statement been made in relation to the fire safety order? If not, then what is the policy? There is considerable confusion over what the department is saying in this respect. Did you think there was a lack of clarity about what precisely was meant by the government stepping back from the extent of its historic role?
No.
Can you help us why?
Yeah, unfortunately, I'm just thinking I recognise this, I kind of remember this. I thought this was...
Well, if we can go to... Let's look at
Can we go down?
Let's look at the foot of page 2. And you say this. Can you see your email there, 10th of August?
Yeah.
You said, my view is that the last sentence is absolutely wrong, but I don't know what has been said previously or where. And that last sentence was, however, government has stepped back from this role and tends to leave it up to the sector.
Yeah, so yes. I mean, I think that is true in relation to the work we were doing or supporting on the development of competency for risk assessors, but I think the context of this, I think, was broader guidance, and I think it was the Fire Sector Federation or Partnership really maybe having a green light, which I hadn't been aware of until I'd read this, that we were somehow interested in them rewriting the guidance for responsible persons that was made available under Article 50, and that I think is where we hadn't gone as far as stepping back from that at this point. I just think this is talking about something slightly different.
You're not talking about fire risk assessor competency?
No.
Good. Right, can we move on to a separate topic, which is definition of common parts under the order? And I'm going to ask you about a letter that was sent by Commissioner Ron Dobson to Brandon Lewis on the 11th of December 2012.
Yeah.
Now, if we go to that letter, CLG *000 0274. You can see it's addressed to Brandon Lewis, who was then the Fire Minister. I think he'd succeeded Bob Neal. Have you seen this letter before, first of all?
Yes.
Would you have seen it at the time it was received by the Minister?
Yes.
Now, this document sets out various recommendations following the LFB's investigation into the Lacknell House fire, and before, crucially, the inquest started in January 2013. Now, we can see at the bottom of the screen there the first and second recommendations. The first one commended this, that the government provide further guidance regarding A, which parts and areas of buildings containing multiple domestic premises can be described as parts used in common parts, and B, how the fire safety order is intended to operate in relation to these premises, where the responsible person does not necessarily have control over features affecting common parts and/or common fire precautions. Recommendation 2, that when CLG's sleeping accommodation guide is revised, consideration is given as to how the guide might provide greater assistance for risk assessors, owners and managers as to how they, as responsible persons, might comply with the order with regards to the common areas of domestic premises. Now, first of all, did it fall to you to respond to Commissioner Dobson's letter?
Yes.
Was there any discussion with the Minister about how best to respond before you put pen to paper?
No, I don't think so, no.
Would it be unusual for you to have preliminary discussions with the Minister as to how best to respond to particular pieces of correspondence?
Yeah, very.
Now, your reply is at LFB 000 32153. Now, you've seen the response deals with the scope of the fire safety order and definition of common parts within it. The final paragraph on this first page says this: although ultimately only the courts can decide, we have no evidence to suggest that the order was intended to apply generally to the structure of a block of flats. In brief, this is because it would be artificial to delineate the domestic premises for the purposes of the order in such a way that it excludes the structure, such as external walls, around a flat. We consider this is the case regardless of whether the structure is, in property law terms, comprised within the lease or tenancy of a flat, because, considering the variety of possible arrangements and extent to which various combinations might apply in one building, the results are anomalous. We therefore do not consider that the order could have been intended to apply in this way. Now, on one reading, the letter appears to contradict itself. On the one hand, you say that the order was not intended to apply generally to the structure of a block of flats, but on the other hand, you say it would be artificial to delineate premises so as to exclude the structure around the flat. Is that a fair observation to make in relation to that paragraph?
Yes, I think so. It's always given me some difficulty, and it is a huge regret that at the time I didn't really bottom that issue out.
Before responding
But-
to the Commission... Oh, sorry.
No, no,
Ms.
sorry.
Upton.
Did you want to say a bit more?
No.
No? All right.
Before responding to the Commissioner's letter, did you seek any legal advice on the correct approach to be taken to the common parts?
Yeah. Yes, and it was very clear that it wasn't clear, and I think this response reflected that lack of clarity, although I should have done more to understand and put it in plainer English, possibly.
But looking at it from a slightly different perspective, would it be fair to say that there was a lack of clarity within the department itself about the scope of common parts for the purposes of the order?
Yeah, yes, I think that's absolutely the case. Yeah, yes. I don't think it had been thought about, particularly at the time of when the legislation was.
Now, can I turn to the question of competency of fire risk assessors, as touched upon by the Commissioner's letter of the 11th of December? And if we could go back to CLG quadruple 0274/2. And we can see there recommendation 7, which read that government provide guidance for the responsible person as to how they might assess that the risk assessor has sufficient training, experience and knowledge to carry out a suitable assessment of the risk in complex and high-risk premises. Now, that recommendation is the subject of an explanation at the bottom of page 7 in this document. Thank you. And you'll see there the explanation says this, next to the word note and a colon. This issue was identified early on in the investigation. Since then, the Fire Risk Assessment Competency Council has been established. Although the council is in its infancy, it seems likely that it will address the issues raised in Recommendation 7. However, Recommendation 7 has been included for completeness. Now, we can go back to it if you'd like, but there's no need to. But in your reply to Mr. Dobson, you didn't address Recommendation 7.
No.
Why not?
I think on the basis of this test, we don't say more than we need to. He was clearly aware and had some confidence in the work of the Competency Council.
But there's no good reason stopping you simply saying that, was there, in the response to the Commissioner?
No.
No.
But I think I didn't say something else either in the letter, did I? Oh, sorry, I'm
Well,
jumping ahead.
Well, that begs a number of questions, but you certainly didn't respond to Recommendation 7. Now, the reply was in a letter from Brandon Lewis to James Cleverly, Chairman of the London Fire and Emergency Planning Authority, dated October 2013, and we can go to that, which is at LFB 0005899/2. Apologies. Do you want to go to page 1 just to make sure so you can see what I'm looking at? There we go. Now, if we can turn to the second page and look at the second paragraph on the second page, you wrote this for your minister. Finally, your letter notes that London Fire Brigade did not receive a response in respect to the recommendation that the government provide guidance to the responsible person on how they might assess that the risk assessor is competent to carry out a suitable assessment of risk in complex and high-rise premises. Fire Sector Federation published in February 2013 the competency criteria for fire risk assessors that had been developed and agreed by the fire safety sector. These criteria, which have been adopted by a number of certification bodies, was published alongside guidance for responsible persons looking for help in finding an independently certified competent fire assessor to help them comply with their duties under the fire safety order. The guide is available on the Federation's website, and my department has, along with the Chief Fire Officers Association, encouraged individual fire and rescue authorities to make it available to the public on their websites. Had there been any review by this stage, so it's October 2013, of the effectiveness of the FRAC guides in dealing with the problems about competency?
No.
Had anyone suggested any such review of their effectiveness?
No.
Could we now turn to a separate topic, which is the letter to DCLG that the Secretary of State received from the Coroner who sat on the Lacknell inquests. Now, the Secretary of State received what was then described as a Rule 43 letter, and it was dated the 28th of March 2013. We can find that letter at HOM 000 45865. And could we turn to page 2? And in particular, the text under the subheading Fire Risk Assessments pursuant to Regulatory Reform Fire Safety Order 2005. And the letter said this: the evidence adduced indicated that, notwithstanding publication of your Department's 2006 guide, Fire Safety Risk Sleeping Accommodation, and of the Local Government Association's August 2011 guide, there remains uncertainty about the scope of inspection for fire risk assessment purposes which should be undertaken in high-rise residential buildings. Evidence was adduced which indicated that inspection of the interior of flats or maisonettes in high-rise buildings was necessary to enable an assessor to identify possible breaches of the compartment which have the potential to impact on the fire safety of the resident or others. It is recommended that Government provide clear guidance on the definition of common parts of buildings containing multiple domestic premises, inspection of a maisonette or flat which has been modified internally to determine whether compartmentation has been breached, inspection of a sample of flats or maisonettes to identify possible breaches of the compartment. Would you accept that it's plain that the Coroner concluded that there was uncertainty about the scope of inspection in fire risk assessments in high-rise buildings?
Yes.
And in particular, there was a lack of clarity regarding the definition of common parts in the order.
Yes.
Now, if we can go to your first statement, which is at HOM 000 46040/10, and if we could look at paragraph 35, you said this: I was responsible for the submission dated 17th of April 2013 to Parliamentary Under-Secretary of State with Responsibility for Fire, Brandon Lewis, on matters under the heading Fire Risk Assessments pursuant to Regulatory Reform Fire Safety Order 2005. It recommended that the Government provide clear guidance on the definition of common parts of buildings containing multiple domestic premises, inspection of a maisonette or flat which had been modified internally in order to determine whether a compartment has been breached, and inspection of a sample of flats or maisonettes to identify possible breaches of compartmentation. You go into paragraph 36 to say, my submission advised that the LGA's guidance has been well received and was well known across the housing and fire sectors. It had been evaluated by the LGA in 2012 and found to be fit for purpose. Now, the first question is this: what were the terms of the 2012 review to which you were referring there?
The LGA engaged with the people who'd been involved. I believe the LGA led that review.
Can we go to, if we go to HOM 000 23280, now this document's entitled Fire Safety Guidance in Purpose-Built Blocks of Flats, Project Evaluation July 2012. Is that the review that you're referring to in paragraphs 35 and 36 of your first statement?
Yes, although I don't think... I think I hadn't realised that this was here, but yes, definitely.
This is what you had in mind?
Yeah.
Now, if we can go to the top of the fourth page, there's the heading Gaps in the Guidance. And it said this: although 70% said that the guidance did not have any gaps, the following key issues were highlighted as areas that stakeholders wanted more information and guidance on: flat entrance doors, ownership and enforcement, vulnerable people, personal evacuation plans, competency of fire risk assessors. Why were you satisfied, given that feedback, that the LGA guide was, quotes, fit for purpose in respect of the concerns raised by the coroner?
I suppose because you can never be at 100%, but generally the feedback had been very positive. I think that was covered in the submission. I don't know why I didn't spend more time thinking about this in the bigger scheme of things. But we had done our best, I think, to address some of these issues with the guidance.
But is it fair to say that when you were looking at the guidance, you didn't have this report, and in particular this page of the report headed Gaps in the Guidance, on your desk at the same time to check whether the LGA guide actually did address these particular points that had been identified?
Yeah, I think so. I can't really remember this.
It didn't have any impact on your thinking then?
I'm not sure. I'm sorry.
Could we look at HOM 000-23279? Really, it's the second email at the bottom of the page. And it's an email from, is it Caroline Bosday or Bosdet? To you, dated the 31st of July.
Right.
2012. There we go, thank you. You received the draft evaluation report, which you then forwarded to Brian Martin, Mary Marshall, Dawn Eastmead, Peter Wise and others. Mm-hmm. And if we go to the top of the page, you say this: hi, Brian, Mary. You'll be interested to see this draft report, which demonstrates that the PBBF guidance has been really positively received by the sector. Now, PBBF is the LGA guide, isn't it?
Yeah, purpose-built blocks of flats.
Headline results: 92.2% said they believe the guidance was effective in overall terms in contributing to improving the fire safety of residents in purpose-built flats. 86.6% said that the guidance helped them understand their legal responsibilities. 76.9% said that the document was easy to use. There remain some issues about take-up across FRAs and consistency of approach, presumably fire and rescue authorities there, which I will raise with EWG in due course. What's EWG?
The Enforcement Working Group.
And grey areas around fire safety and sheltered housing, which of course was not within its scope, although helpful principle-based advice was included. I will revisit this with the Fire Safety Federation group when we met in the autumn to discuss clarifying technical standards in relation to sheltered housing. I don't think I have any comments on the draft report, though we'll ask LGID, who's that?
That was what LACORS became, Local Government Improvement Directorate, I think, but I can't remember. Acronyms changed all the time.
They do. They will ask LGID for a list of respondents, particularly fire and rescue authorities, and an indication of where they are on the spectrum of using it or not. Did you intend to raise the gaps in the guidance that we've just been looking at as part of the evaluation exercise with either EWG or some other group?
It doesn't look from this that I was intending to.
Did you discuss the gaps in the evaluation report, or the gaps identified by the evaluation report, with anyone on this distribution list, so Brian Martin, Mary Marshall, Dawn Eastmead, James Webb, Mike Larking, or Peter Wise?
I can't remember.
Is it likely, probable, unlikely, improbable?
It's more likely than not, but again, I don't remember. I mean,
Now, turning back to your first witness statement, you say on page 11, which we can find at HOM 000464040/11, and if we look at paragraph 36 and the end, you say this: I reported our forthcoming meeting with the LGA to consider whether, in light of the Rule 43 letter, there was a case to consider whether any amendments were needed to the guidance, including on the definition of common parts. Now, can you remember whether you received any decision, instruction, or whatever from the Minister, Brandon Lewis, following your advice?
no, I would have had no feedback.
Was there anything discussed, whether from the Minister or any special advisor or anyone in his private office, about what was being done about the definition of common parts, for example?
No, I don't think so. I don't believe so.
Now, you prepared a submission to the Secretary of State to inform his response to the Coroner's Rule 43 letters, and that can be found at HOM 0004403. We can see from the top right it's dated the 13th of May 2013, so 6 weeks or so after the letter had been sent. On page 2, and at paragraph 7 of the submission, you said this: we are content, in the third line, we are content that the LGA guide provides sound advice on both the fire risk assessment process and the issues that housing providers should consider if they are to ensure an acceptable level of fire safety. It also identifies appropriate approaches to risk assessment, including sample inspections of individual flats, and provides examples of the fire safety advice landlords may want to make available to their residents. Now, on what basis had you satisfied yourself that the LGA guide provided sound advice?
Through that review process and feedback from, I suppose, informal feedback, that it was good guidance.
Given that the coroner, after hearing some months of evidence, had concluded that the question of the scope of inspection remained uncertain, didn't that, or shouldn't it have, prompted deeper reflection on your part about the need for a more considered reflection and consideration of the contents of the LGA guide?
Yes, exactly. I think by this point it was clear that we couldn't clarify easily the scope of common parts, and we couldn't give guidance on that. So,
was there an element of ostriching about that, in the sense you put your head in the sand because it was too difficult to resolve?
yes, I think I understood it could only be resolved through a proper review of the legislation, which was not on the cards at this point. So it was, I think the guidance, we'd done our very best in the guidance to make sure that people knew how to assess the risks throughout the whole building, while the coroner's focus was on the fire safety order, the Housing Act provisions, which I'm definitely not an expert on, but the whole consensus in the department at the time was that the Housing Act provisions were sufficient to manage the risks from fire and by building owners. But I do take the point of course, that this was an opportunity that there may be an element of that in the too difficult box at this stage.
Well, the coroner had heard evidence at inquests into the death of 6 people. After hearing that evidence, she'd identified a lack of certainty regarding the definition of common parts. That ought to have prompted you to review at least that issue arising in relation to the order, shouldn't it? In more detail than you did.
Yes, well, we did go on because it came, I suppose, the sequencing in my mind, as I recollect things, we had the letter from Ron Dobson, London Fire Brigade, and which had been copied to the coroner. I'd then replied to, or the minister had replied to Ron Dobson, and had also copied in the coroner, and we'd reflected in that letter that we were looking again at common parts, although it was a very complex area. I didn't follow the discussion or the Lacanau House inquest, and I just had, so the recommendation came, which I'm not to say it didn't come up during the evidence, but it came more through London Fire Brigade, in my mind, than it did through the actual narrative verdicts, I think.
It's easier than that, though, isn't it, Miss Upton? The question of common parts had been set out explicitly in the letter the coroner sent to the Secretary of State. You could and should have done more to consider the definition of common parts. Do you accept that?
We should, yes. It wasn't clear that we did consider the definition of common parts, and it wasn't clear that I think whether we should have done more to advise ministers that we needed to clarify it and how best we would do that. We should definitely have done.
Now, if we can look at paragraph 8 of this ministerial submission on page 2, you said this: the LGA plan to undertake a quick review with the housing sector to ensure this guidance adequately addresses the issues the coroner has raised. DCLG officials have offered to assist the LGA where appropriate. What was the purpose of this, quotes, quick review, close quotes?
To find out how the guidance had been reviewed, how it had landed with the sector.
Who was to decide the scope and parameters of the review?
The LGA.
Given that you were responsible, ultimately, you, I mean by the department, Miss Upton, were responsible for regulating these matters, is it right that you could have commissioned or asked the LGA to undertake any form of review that you considered necessary and appropriate in order to answer effectively and fully the coroner's recommendations?
We could have had there been resource to do that. I admit it's not a question. I think that I certainly asked whether there was the resource to do that. But it had been quite an effort to secure the funding to actually produce the guidance.
Given the complexity of the issues, what were the reasons for deciding that only a quick review was necessary and appropriate?
I think that was again a resource. The coroner's letter had come in. It was important to know how the sector felt about the guidance. I think the timing of that, it was to satisfy ourselves that it was kind of good enough, fit for purpose, and it had. We had recognised how difficult the issue of common parts was, but it had given guidance to people on how they might assess the risk in flats and in the common parts, and how they might make sure the the premise, the whole building was safe.
Now, the reference there is to consulting the housing sector. Did that include fire and rescue authorities and fire and rescue services?
I don't know, actually. I know it says the housing sector. I don't know whether fire and rescue services were consulted.
Now, sticking with paragraph 8, it says this in the third line: as part of this process, we will consider whether it may be helpful to define the term common parts, which is used extensively in the guidance to describe those areas which fall within scope of the fire safety order, but which, in terms of these regulations, relate only to those areas which constitute a workplace or which provide access to or from one. Now, did you mean there that whether the phrase common parts needed to be defined was intended to be considered as part of the LGA review?
Yes, I think I probably did mean that. Yes.
Are you sure about that?
No, not really. Could you repeat the question? I'm sorry.
Yeah. Did you mean that whether the phrase common parts needed to be defined was going to be considered as part of the LGA review?
Yes, I think. Well, I think it came out Yes, I think I must have meant that. Yes.
At least if it wasn't going to be them.
Because it was answered, wasn't it, in the...
And if it wasn't going to be them, who by?
Yeah.
So if we can go to CST quadruple 05484. Here's a letter from Helen Murray, who's the head of programmes at the LGA. It appears to be a round-robin letter sent as part of the LGA review. Do you remember seeing this at the time?
I don't remember seeing. I don't. But that's definitely not to say that I didn't.
It just doesn't stay in the memory. Can we look at the penultimate paragraph? We see that consultees were given until the 30th of May 2013 to respond. Did you discuss with Helen Murray whether that was sufficient time for consultees to respond properly, given the nature and complexity of the issues covered by the LGA guide?
No.
Did you think, therefore, it was about right from your perspective, 6 weeks?
Yes.
Looking at the fourth and fifth paragraphs of this letter, Miss Helen Murray said this: fire safety in purpose-built blocks of flats was developed in response to requests from the housing sector for specific guidance in this area. DCLG considers that the guidance provides sound advice on the fire risk assessment process and on the issues that those responsible for purpose-built blocks of flats should consider in ensuring an appropriate level of safety. However, like the LGA, DCLG is interested to know if you, as a key stakeholder, are satisfied that the issues raised in the Rule 43 letters are adequately addressed by the existing guidance. Now, do you know why why the view of DCLG that the guidance provided sound advice was set out before the outcome of the consultation itself?
No.
It's slightly, well, it gives the
It's a
indication,
leading question.
well, quite, that the matter had been prejudged.
I didn't draft that letter, but that was. I can see where that's coming from.
Did you have any discussions with Helen Murray as to the guidance or the emphasis that this letter would contain in terms of echoing the department's point of view?
No, I suppose my contact. I suppose I'm not sure I ever spoke to Helen Murray. I suppose Eamon was my contact at the LGA.
But it tends not to encourage a full and frank provision of views, doesn't it? If the LGA is already indicating that the department considers the advice to be sound.
Yeah.
Is that a yes?
Yes, that's a yes.
The paragraph referred the reader that we've just considered, referred the reader to the Rule 43 letters, but the letter did not expressly ask recipients whether it would be helpful to define the term common parts, did it?
No.
Was that a result of a considered discussion between you and the LGA, whoever at the LGA you were talking to?
No, I don't think so.
And so if the review was, as you indicated, to seek the views of stakeholders on common parts, that particular issue wasn't flagged up in the covering letter, was it?
No.
Can you help us as to what you did to ensure that stakeholders' views on the definition of common parts would be sought?
No, I don't remember doing...
Did it cross your mind at all?
No. Sorry, can I just be clear? Was this the letter that generated the report that said that there were still issues?
Well, this is the... No.
It's the timing. I'm sorry, I lose the sequencing of these.
No, if we maybe de-amplify the letter. This is sent in May 2013. It followed your request, the LGA, to carry out or to conduct a consultation exercise in relation to the LGA guide.
Right. Following the coroner's letter.
Following the coroner's letter. You'd indicated earlier that this review was to ask for views on the definition of common parts. And my question was a simple one. This letter does not refer to that issue at all, does it?
No.
So on what basis were you going to obtain the views of stakeholders on the definition of common parts in order to reach a considered view to respond to the coroner?
I think we would have waited to see what they said if they'd seen the letters. I suppose we left it open to them. We weren't very directional in what we wanted them to look at, but if they'd come back and said common parts, we would have...
But you weren't directional at all, you just didn't mention it at all.
No, but we sent the Rule 43 letters. Did we attach them? Yes. So the stakeholders had the Rule 43 letter and could have come back on anything, I suppose, within that. No, we weren't directional, I accept.
Or at all.
Or at all.
Why? It wasn't just the coroner's letter that flagged up this issue. You'd also had the letter from Commissioner Dobson in which he said clarity was required. Given that you had a letter from the Commissioner of the LFB, given that you'd had the letter from the coroner who'd carried out inquests into the deaths of 6 people at Lacknell, why did this letter not deal with an issue which had clearly been the subject of a recommendation from the coroner, the definition of the common parts under the order?
I suppose because we knew... I suppose because we felt we had covered the point, or the point had been covered around how they needed to do it, and actually, for the purposes of delivering safe premises, the guidance told people how they needed to do it. What I think was much more difficult was amending the order to do it, or whether, and so there were two different, I suppose, approaches to it, which was the issue of actually we could only amend the fire safety order with legislation. It was early days.
Was it?
Well, no, not by then. I suppose not by then. We could have.
It was 7 years in by this stage.
Yes, we could have. Yes. I suppose the broader context of this is the fact that we had been through, by this point, the red tape challenge process, the whole deregulatory agenda, I think, where it had been very clear that ministers hadn't wanted then to review, that put the fire safety order partly as a hadn't wanted to put it through, given how new it was, and I think the idea was that 10 years on would be a good point to review the legislation. There were we'd made the easy tweaks we could make without opening it all up to full legislative review, for which would have been, I suppose, extremely resource intensive within the fire directorate. And
if I can stop you there, just
yeah.
Had any minister in the department directed, decided or instructed you that there was to be no review of the 2005 order?
No.
So you assumed that was the case?
Yes.
Did you check whether that assumption was sound, either with your immediate superiors or indeed with either the Secretary of State or the Fire Minister himself?
Kind of.
Did you do that?
Yes, in the discussions around, I suppose it was always quite clear within the unit that the fire safety order was just too difficult to beast at that particular time to handle. But that was through informal discussions. What do we do? It's
within the unit?
Yeah.
And so the matter never got to ministers?
No, we never put advice to ministers.
Could we... So I'm just wondering whether this is an appropriate point.
Well, how does it suit your questioning?
As good a time as any, being practical about it, sir.
Probably a good idea if we had a break, isn't it, Ms Upton? We'll do that now. We'll stop now and resume, please, at 25 to 4. And as before, please don't discuss your evidence with anyone. All right?
Thank you.
Thank you very much. Thank you. 25 to 4.
Thanks, sir.
Thank you. Would you ask Ms Upton to come back in, please? Okay. All right, Ms Upton, ready to carry on?
Yes.
Thank you. Yes, Ms Katia.
Thanks, sir. Miss Upton, can we go back to Eric Pickles' response to the coroner? And that was sent on the 20th of May 2013, and we can find it at HOM 000 460 77/2. Now, what the then Secretary of State said in the second paragraph of that letter, and looking at the third line, was this: however, we are not complacent. I fully support the Local Government Association's proposal to consider, with my department and other partners, whether there are any implications for the guidance arising from your Rule 43 recommendations, which may need to be addressed in a revised document. My officials are engaged with the Local Government Association on this matter. So the response to the coroner seems to have left open the possibility that the LGA review would prompt a revision to the LGA guide, which would address the coroner's concerns. Is that was that the intention behind these words?
Yes, that we would. Yes, the intention is that we would look at what the review said and consider whether anything needed to be done.
So the door was open to that extent.
Yeah.
Could we go to the LGA's review, which is HOM 000 460 40/11. Sorry, turning to the review. If we just go to your statement first, though. So HOM 000, thank you. And if we look at paragraph 39, you said this: the LGA informed you in June 2013 that there had been little response from stakeholders on its proposed review of the guidance, which was interpreted as an indication that the housing and fire sectors were content that the guidance remained appropriate. Now, if we can go to HOM 000 46074 and go to the foot of page 3, we see an email there from Eamon Lally at the LGA to you on the 21st of June 2013, and he wrote this: we've had very little response to our request for stakeholders to review the guidance. However, we've had a very robust endorsement from the authors. Not sure there is much else we can do, so we will take down the caveat from the web page and reword the web page introduction to refresh the endorsement. When you received that email, did you ask how many people had in fact responded?
I don't think so.
No. Did you ask to see any of the responses?
No, I don't think so.
Were you concerned by the fact that there had been very little response?
No, not really. I suppose it's interesting there wasn't. I should have been more interested in it. I should have been, but it wasn't just me who should have been interested. I suppose housing colleagues should have been interested as well.
And would you agree?
I am now.
Well, would you agree that a robust endorsement from the authors was not quite the same as obtaining the view?
Oh, absolutely, yeah.
Now, if we can go back to the middle of page 3 in this chain of correspondence, you say in your response to Mr. Lally this: like you, we have had no indications from the housing sector that the guidance was in need of revision following the outcome of the inquests. Wasn't it perhaps more accurate to say that you'd had little indication either way because of lack of engagement with the consultation?
I'm not. Yes, I'm not sure. I mean, the consultation would have been one indication, but I suppose housing authorities could still have been writing to ministers or to the department with concerns around it.
And you don't recall anything coming through?
Other than Ron Dobson's letter, which seemed to stem from something which I suspect we'll talk about.
Now, in your first witness statement, which we can find at HOM 000 460 40/11, we look at paragraph 39 and the first sentence. You said the LGA informed me in June 2013 that there'd been little response from stakeholders on its proposed review of the guidance, which was interpreted as an indication that the housing and fire sectors were content that the guidance remained appropriate. Now, if we can go, actually, if we do need to go to it, recipients had been asked whether you as a key stakeholder are satisfied, and the fact of a low response may indicate dissatisfaction. Would you accept that as a possibility?
I suppose I must accept that as a possibility, but this guidance, when we started the process and pulled them all together, it was a very, very engaged sector with this guidance. It was almost, given how totemic, I suppose, Lakanal House had been, it was conceptually inconceivable with hindsight that nobody would have been interested in this guidance when it had been the thing that was most wanted after the fire and seemed to address the points, with the exception of common parts and defining that for the purposes of the order. My assumption had been genuinely that the fact there was very little response to this was a positive indication that it was embedding. But yes.
Given the vociferous sector.
Yes.
Now, can I turn to a letter that was sent by the coroner to the Fire Sector Federation, the FSF, also sent at the end of March 2013, and we can look at it briefly, which is at HOM 000 4356. Do you remember seeing a copy of that letter at the time?
Yes.
And could we go to page 2 and look at the third full paragraph from the top of the page, which starts, "It appears that your federation is well placed to shape policy at a national level relating to the scope of fire risk assessment, and in particular with regard to assessment of high-rise residential buildings, and to offer guidance as to how assessment should be carried out. I trust that your federation will consider whether it has a role in clarifying the scope of fire risk assessments and in offering further guidance as to training of fire risk assessors." Now, if we turn to HOM 000 47440, we see an email from you on the 3rd of April 2013 to colleagues within the department, in which you comment upon the extract of the coroner's letter, which we've just read, and you say this: "Interesting. This will do much to embed the FSF as a real entity, and so it'll be interesting to see how they handle it." Why did you consider it to be interesting?
Because I think there was such a very diverse coalition. The Fire Futures had tried to pull them together into a sector leadership body. And I think the fact that the coroner wrote to them was it did much to make them a thing outside of the department, if you know what I mean.
Did they seem to
gave them a credibility and status.
Now, Flowing from that, I'd like to turn to discuss with you proposals for a passport scheme in relation to FRA competency. And that report was prepared by Dennis Davis, who we heard from last week. And I think you became aware of a paper that was produced for an FSF forum meeting, and which was to take place on the 1st of May 2013. Now, if we go to the report itself, which is HOM quadruple 01351, now, we know that this was prepared for the Competency and Accreditation workstream of the Fire Sector Federation, and it contained a proposal which we can find at page 7. And under the heading Competency and Assessment, it said this: the FSF was not to be seen as a third-party competency council, but did have, as the coroner put it, national influence, and as such should act as the guardian of the gold standard. Therefore, the objective should be to create a quality assurance board charged with ensuring the parties, such as those who are signatory to the CCFRA, abide by their commitment and introduce processes to enable their risk assessors to clearly demonstrate competency. Now, I think the somewhat inelegant abbreviation there, CCFRA, is a reference to the guide for choosing a competent fire risk assessor. Is that right? Can you remember?
Possibly. I'm not sure I would have got that acronym now, but I think you might be right.
Thank you. Now, underneath that paragraph, you'll see there are a number of a series of numbered points. And if I could look at the second and third ones in particular, Miss Upton. Number 2 says this: the FSF should recommend to each certification scheme owner in the CCFRA that their scheme offer specific recognition against each of the existing 9 areas covered in the CCFRA, that the individual assessor is judged competent, and this would be known as a passport. 3, that each passport scheme should also offer a graded level of competency in each area from 1 to 3, where 3 is highest, and each level reflecting skills and understanding. Do you remember those recommendations?
A little bit, yes. Yes.
Well, if we go to your second witness statement, this may help, which is at HOM 0005082/13. And we can see at paragraph 45 at the top of the page, you say this: my initial view was that the paper indicated a positive FSF approach to working with the LGA, and that anything they could do to promote awareness of fire safety issues and the availability of competent risk assessors within the housing sector was to be welcomed. However, others read the FSF's paper more closely and drew their reservations to my attention, including Sir Ken Knight, who, in a later email on the 29th of April 2013, flagged the FSF's intention to write to LGA with proposed amendments to the recently issued PBBF guidance. Like my colleagues, I felt this introduced a risk that confidence in the achievements to date could be undermined. Why was there a risk, in your view, that confidence in the LGA guide would be undermined if the FSF developed a passport scheme along the lines proposed?
I'm not sure. It was more around, I think, is it the confidence, and it was really around the handling of it. I think that didn't tell us very much. I think I was worried that they may react rather than consider a way forward, and that in reacting, I kind of agreed it may undermine confidence. If the Fire Sector Federation instantly said we need to review the recommendations with very little evidence behind that, other than this one paper, it was hard to see what was behind that paper. But in terms of it was more in handling. We would want to be clear that they didn't do anything, I suppose, very reactive without thinking about the wider implications.
But haven't there been concerns about fire risk assessor competency for some years by this stage? The
Yes,
problem was
and
clear.
they were tasked with leading the work, and so I was optimistic that this paper demonstrated that they were keen to lead the work. It was more for me really around, I suppose, how they may go about handling that work programme rather than.
But did you have any evidence or information that gave you cause for concern that there would be a risk to confidence in the guide if the FSF proceeded as they intended? I'm just trying to understand what the factual basis was of your fear, or was it more in the level of a sort of hypothetical apprehension?
Yeah, I think I just worried at the very kind of narrow view that the Fire Sector Federation might have had. It wasn't an outward-facing body. I'm not sure it hadn't spoken to business. It seemed it was really talking about how it police itself, and some of these issues, a lot of the members of the Fire Sector Federation had been on the Competence Council, risk assess the
council.
The council, sorry, yeah, thank you, the FRAC, and had agreed with, because the discussions there had gone through, do you have a graded level of competency, and that had been kind of talked through, and the difficulties around that established, and it was just clear that there needed to be more thought. And it seemed to me that this letter, this report, was aiming to really enable the Fire Sector Federation to respond to the coroner. And it was important, I suppose, to me that that response was as measured as possible, rather than kind of saying we need to review the purpose-built flats guidance.
Can I just ask, when I read this, it seemed to me that your last sentence, where you say, like my colleagues, I felt this introduced a risk, I rather read this as referring back to the proposal to suggest amendments to the recently issued PBF guidance. Is that the right way to read it, or does it refer back to the whole business of a competency passport?
Yeah, I think when I drafted my statement, I was definitely thinking of it in the context of the passport scheme for competent risk assessors.
Right, thank you.
And I think that's clear from the first sentence of the paragraph. That's how I read it. But could we go on to some email correspondence following circulation of the report from the FSF? And could we go to CLG *0000527 /1? You see at the very bottom of page 1, start of an email from Brian Martin. If we turn over the page to the head of page 2, he said this to you and Ken Knight, copying others. Looks to me like the FSF is in danger of trying to do more than is necessary, desirable, or within its ability. Did you agree with that opinion?
I wasn't very close to the Fire Sector Federation, particularly, but they did have grand ambitions, and I'm not sure how much I agreed with it, but I was certainly sympathetic to Brian's.
A broad sympathy.
Yeah.
You replied to Ken Knight and Brian Martin on the 29th of April, and it's at the top of page 1 of the chain. Oh lordy, let's have a meeting sooner rather than later to see what we can do to steer the FSF away from its worst excesses in respect of control freakery, i.e. the development of a passport scheme. it seems that intervention is not without risk, and we need to think about how we can best manage it. Now, then you conclude, Ken and Marie, will you set something up, please? Sir Ken had left position as Chief Fire and Rescue Advisor in January 2013, hadn't he?
Yeah, yes.
Why were you still emailing him in April 2013 about these matters then?
Well, I suppose he'd drawn it to my attention, the original email, so he was very involved in the sector anyway. To be honest, I don't think I gave it any thought at the time. I was just responding.
Was the fact that he was still around, that it seemed perfectly normal for you to direct him to set up a meeting to discuss the matters raised by the FSF report?
Yes, I think I don't think I was directing him to do that. I think I was just probably acknowledging that his diary took precedent over mine, and so maybe if they picked a time when we could talk about it.
But I think you're probably focusing on the wrong bit of my question, which is probably because my question wasn't succinct. But was it the fact that he was around that you considered? Oh, sorry. Was it the fact that he was still around a lot or around at all? That it seemed perfectly normal for you to retain him in these discussions?
Yes, I think he'd flagged it with me. I think I'd been unaware until he'd sent the email, and I just...
You said you didn't have great knowledge of the FSF, but on what basis did you form the view that the scheme was at least evidence of its worst excesses in respect of control freakery?
That's a terrible phrase. Yeah. I think they found it very, very difficult to agree anything amongst themselves, and I think there was an element of who shouted loudest. I don't think they were particularly well joined up, and I always suspected that whoever wrote the paper, it was their view that was predominating.
But that's not the criticism that's made here, though, is it? Because you're saying steer the FSF, so the organisation, not any individual there, away from its worst excesses in respect to control freakery. That suggests inordinate control rather than an insufficiency of control from a lack of coherence, doesn't it?
Yes, and I suppose it was the basis on which, and understanding the basis on which they sought that control was kind of what I really wanted to get under the skin of later, I suppose. But my immediate concern was that they didn't submit an ill-informed response to the Rule 43 or set out things that would compromise confidence in both the guidance and the work of the FRAC.
Now, it appears that there was a meeting between you, Brian Martin, Anthony Maud and Sir Ken Knight on the 30th of April 2013, i.e. the following day. Do you remember that meeting?
No, I think we, well, not in detail, but...
Can you remember the gist of... Sorry, can you remember that meeting?
Yeah, I think Anthony Maud was the... my colleague Anthony Maud was the person attending the meeting as stakeholder manager. I think we wanted to understand the background more to the meeting, where this might have come from, to get more information, and to make, I suppose, Anthony aware of our concerns around where we were with the Rule 43s and the sector response to the guidance, which had generally been very positive, notwithstanding the issues that they had identified, and also the competency, the risk assessor guidance which was available. I think we just wanted to steer them away from writing a response that says we're going to change everything because we weren't aware of the evidence.
And this, I suppose one of the aims of government policy that you've explained to us during the course of today is for there to be a sector-led approach. You got a sector-led approach and didn't seem to like it much. Is that a fair observation? You wanted to retain control, didn't you, still, over the process?
I think we wanted to make sure that that any changes to the process were clearly understood and that there was a plan around doing that. But yes, I think...
So never seek for what you want in case you get it is the lesson here, isn't it, Miss Upton?
But, well, yes. I mean, it was up to them, the response they put into the, it was their response to the coroner. I think it was just important that at that meeting with Anthony, we just gave them a sense of a bigger picture that Anthony could relay some of this back to them. But I think the response...
OK, if we can go back to...
Can you just tell us what was wrong with the passport scheme in a nutshell?
I think it was focused on buildings that I think the idea behind it, as I recollect, was that you would be certified competent to do particular types of buildings. Mm-hmm. So, and the way and it would be gradated, so higher risk, people with more competency. But at that stage in the process, the competency hadn't been broken down into that way. It was just a single competency. It was a kind of the necessary evolutionary step towards having degrees of competency within an overarching standard hadn't been worked through yet, as far as I'm aware.
To the layman, that sounds not unreasonable, because some people would be competent to do complex buildings and some people are competent to do any less complex buildings, and the criteria might be worked out in the course of the developing the scheme, but you didn't care for it.
No, I think that was the competency criteria that had been developed had said, well, I'm not, the competency criteria allowed the assessor to say, I'm beyond my competency now. So it was...
Not sure what you objected to, that's all.
I don't think there would have been an objection that work could have been done and delivered. Passport scheme, it just needed more thinking about, probably.
Can we see what was being discussed at the time to see whether that answers the chairman's question? It may not necessarily. If we go to the minutes of an executive group meeting of the Fire Sector Federation, a meeting that was held on the 1st of May 2013, can be found at FSF 0000244. We can see that Anthony Maud attended. Left-hand column about halfway down. If we go to page 4, at the top, we see AM, so Anthony Maud, commented that there was some concern from DCLG on the Criteria and Competency Council work, as it looks like the proposal is to review elements which have only just been agreed following recent discussions. There is concern on the LGA work and guidance, and Dennis Davis's document mentions reviewing this with DCLG confirming that additional guidance is not required. So essentially, your essential concern was not the substance of the scheme, it would appear, but the general problem that it may be perceived to cast doubt or diminish confidence in the LGA guide. Is that, first of all, is that right?
Yes, I think so.
And is that what you directed or asked Mr. Maud to communicate to the FSF at this meeting?
Yes. I think we'd had the results. Yes, I think so.
Now, could we go back to Mr. Davis's document, which we find HOM quadruple 01351/6. Remember, these are the bullet points we were looking at previously. If we can look at number 3, there's the following comment. There was an absence in the CCFRA of reference to risks posed by modification and refurbishment. This could be a new section or subdivision of the existing 9 sections. The 4th point on the same page, there's a recommendation which mentions H1, that's part of the competency criteria. It says this: a greater emphasis on the risks posed by the introduction of new materials, building design, modern engineering practice and building methods was required. And then looking at 5, the importance of gaining access into individual premises rather than just to common areas to be incorporated, highlighting how compartmentation could be weakened by occupiers. Now, would you agree that cumulatively these points represent significant concerns about the adequacy of the competency guidance that was in place at the time?
To be honest, I'm not sure I would, because the competency guidance was signed off by so many Fire Sector Federation members who sat on that group. It was partly where this how plugged in the sector was to whether this was simply one person's view with very little knowledge of who hadn't been a member of the Competence Council. I think that's what I think. It was just something that hadn't been put together with the benefit of full engagement from the Competence Council and of the Fire Sector Federation. The extent to which this reflected everybody's views, I felt was still not clear.
Could we turn to a separate topic, which is the draft paper on a national regulator for fire safety? Now, you wrote a document in December 2013, which was entitled Draft National Regulator Paper. And we can find that at HOM 000-46039. Now, was that document drafted to identify possible options in response to yet another review, which was called Facing the Future?
Yes, I think it was.
And was the paper intended to be the starting point for discussions with Dawn Eastmead?
Yes, I think so.
Can we turn to page 2 and roughly midway down that page? We see a paragraph starting following the Fire Futures Review. And it says this: following the Fire Futures Review in 2011, Minister's expectation has been that the fire sector will step up to the plate and work together to develop a strong self-governing sector, supporting compliance with regulatory requirements through the provision of relevant guidance to industry and others. To date, none of the key players, CFOA, the LGA, or the Fire Sector Federation, had made progress. Did that summary reflect your considered views in December 2013?
Yes.
Was it your view that in effect CFOA, LGA and the FSF had not made any, or indeed any, sufficient progress to address the concerns that various reviews and reports had identified since March 2009 about the competency of fire risk assessors?
Yes. In terms of the speed. That's not to say they weren't doing it, but it hadn't been quick.
You referred earlier, I think, to an optimism bias on your part. I hope I recall that accurately. What had happened to diminish that optimism bias?
I suppose it was just the general thrust of the deregulatory policy. It was the resource constraints, austerity. There were 43 fire and rescue authorities, I suppose all of whom were enforcing the fire safety order in a range of premises. They all did it 43 different ways. There was no common standard of competency of fire safety enforcing officers. I think when you looked at the big picture, there was probably, these were national issues. You know, there were the same types of premises and risk replicated throughout authorities. And if there was, I suppose, a national regulator solely looking at fire safety in buildings and fire safety management and looking at risk and mitigation strategies that everybody could tap into, it would be more consistent for businesses potentially.
But hadn't that state of affairs though existed for some time though? What was it? What happened in December 2013 that caused the optimism bias to diminish?
I think it was the opportunity to be able to feed something in that would change. You know, the Fire Futures was a range of options for consideration, and so it was a kind of look away from the delivery of the day job to actually, could we do something maybe more effective and efficient?
Okay. Can we turn to page 4 in this document, please? And we see there in the options, roughly halfway down the page they start. One is to do nothing. And the title of the second is make additional resources available to identify and analyse options to provide a national strategic oversight of fire safety standards and guidance up to and including the establishment of a national regulator for fire safety. Now, if we look at that first bullet point, it says this: increasing resources available to Fred. What's Fred, or who is Fred?
Oh, sorry, Fred is the Fire Resilience and Emergencies Directorate.
And that's in the department, isn't it?
Yes, that was Neil O'Connor's directorate that looked at everything to do with fire and resilience.
To develop in-house or purchase expertise in technical fire safety issues so that we can provide and/or quality assure independent and high-quality advice to businesses and the enforcing authorities on how to deliver their statutory duties under the FSO. Now, just pausing there for the moment, was it your view that the department did not have, at that time at least, any expertise in technical fire safety issues?
Well,
or any sufficient?
Yeah, we definitely had insufficient. I mean, there was me in the fire directorate who was not a fire safety expertise, and there was the building, Brian Martin, with his technical fire safety from a building regulations perspective, and we were a very small team with lots of things to do. I was definitely did not have the resource or, you know, technical ability to do this within my team, and it was increasingly difficult, you know, to get others in to do it on anything other than an ad hoc basis.
Now, if we can turn over to page 5. It says there at the bullet point at the top, rebrigading regulatory and technical fire safety policy within the Sustainable Buildings Directorate, promoting a more efficient use of DCLG resources and expertise, and developing a more coherent and holistic fire safety approach to the national building stock. What was the... So I don't mean this in an impolite way, but what did that mean in practice?
In practice, it meant that regulatory policy for buildings sat really uncomfortably in a policy department looking at funding, governance, structure of fire and rescue authorities.
Where should it have sat?
Well, it could have sat there, but with a much more resource behind it. But I think there were a range of options for where it could have sat. It could have sat in DCLG, in the building regulations department, because really the strategy around managing building, there was that clear link and understanding of building issues, although it has to be said, building regulations colleagues, I don't think, appreciated that suggestion. Or it could have sat within the HSE. Fire and rescue authorities were enforcing authorities for other bits of legislation.
Just flowing from that, because I was going to ask you about that next. Why did you think that transferring responsibility for policy and enforcement to the HSE was a reasonable or viable option?
Well, because the regime was essentially the same as businesses were used to working with the risk assessment process, where they manage risk down to the lowest, as low as reasonably practicable. HSE inspectors were in high-risk buildings. They had much more, well, I'm not sure they did, it wasn't evidence-based, to be honest, either. But they had more resources than fire and rescue authorities that were losing technical fire safety expertise and focusing on operational and community fire safety much more during this period. It seemed a good fit with the principles of health and safety legislation in workplaces, which is where the order was primarily intended to apply.
We see lower down the page, it's the third bullet point, the suggestion that there be an arm's length independent national regulator for fire safety with a leading role in a number of areas, including developing and maintaining professional competency standards for those providing or auditing fire risk assessments. Looking at the latter element of that, developing and maintaining professional competency standards, wasn't that in broad terms what the FSF was seeking to achieve by its passport scheme?
I was never very clear what they were necessarily intending, but certainly I wasn't, I think, convinced that the SFS would be able to deliver it in the way possibly businesses wanted.
This proposal, the national regulator went no further. Do you know why?
I think it was very... I think it had gone in a paper to ministers and they'd said, no, we're not interested in that, but maybe do a bit more work. This was the bit more work, I think, that I did around it. And I suspect it was just, there was too much going on, but I don't know why you'd have to ask.
But it just didn't go any further.
No.
Now, you say in your first witness statement, we don't need to go to it, that the development of the proposal arose following concerns raised by business in the Focus on Enforcement review that was conducted in 2013 by the Better Regulation Executive. We can go to that review, which is at HOM 0026445/19. We see there in the first substantive paragraph that commercial fire risk assessors, yet again, are addressed by a report, and it said this: many small businesses are using commercial providers to carry out their risk assessments with little assurance available on the quality of their service. And if we go slightly further, halfway down the page, a sentence which starts with the word however. Have you got it?
Yes, sorry, I have, yeah. Sorry.
Thank you. Don't worry, it's quite a way down the paragraph. However, it is clear that many businesses use commercial third parties to carry out the risk assessment. Until recently, no certification or accreditation existed in relation to these services, and none are currently required in the market, meaning that in effect, anyone can offer their services. Some businesses reported overselling by assessors that were also equipment suppliers, and a number of fire professionals questioned the quality of some commercial providers. In practice, a third-party assessment offers no guarantees to a business, and sometimes they will find that a fire protection officer will ask for additional measures beyond those identified in the bought-in fire risk assessment. And if we go to the next paragraph, and roughly down that next paragraph, a sentence which starts with the word, "It should be noted." It should be noted that some business bodies are not in favour of accreditation for third parties, seeing this as another regulatory step, identifying the risk that it may squeeze some smaller operators out of the market, and also because they think it may in time lead to businesses having to use a third-party assessor and thereby lead to increased costs for small businesses. A number of fire industry professionals nevertheless felt there was a good case for certification and accreditation. Would you agree that this is yet another example of concerns raised about the competence of third-party fire risk assessors?
Yes.
At this stage, did this report or comment prompt any further consideration of what to do about the perennially vexed issue of the competency of fire risk assessors?
Well, I mean, no, I think it was you get no, there's as much positive probably in this and as much how business viewed it. I think that if the question, which I know it probably isn't, is did we act on any of this, it did prompt the thought around probably a national regulator to help everybody out in this space, to raise standards across the piece. But there was no appetite for more regulation.
Could I deal with just one final topic before we rise today, sir?
Yeah.
It's the Building Research Establishment report from 2015, Miss Upton. It was a review commissioned by LFIPA.
Oh, yes.
In 2015, and I think in or about January 2015, you became aware that the LFIPA had commissioned the report, and it was about the effectiveness of the FSO.
Yeah.
In broad terms, have I summarised matters right?
Yeah.
LFIPA had established a working group after the Lacknell inquests and following the letter that they had received from the coroner, is that right?
Yes, I think so.
Now, if we can go to CLG 000-35525. This is a chain of email correspondence in January 2015 concerning the project. Could we look at your email, which was sent on the 20th of January 2015, which is at the head of this email chain on page 1? And could we look at the 5th line of the 3rd paragraph? And there you explain that the department corresponded with LFIPA and officials on this work late in 2013 and addressed, as far as we're able, the issues that were raised with us for clarification. The Lacknell House Working Group completed its work in July 2014 and passed 4 issues on to the LFIPA Strategy Committee to take forward. These were as follows, and I'd like to look at the first 2. The regulation of leasehold properties within high-rise buildings, how landlords are dealing with leaseholders making modifications to door, interior walls, etc., which potentially compromise the fire safety of buildings. Second point, the need for a recognised government standard for competent persons carrying out fire safety preventative measures. Now, in terms of the substance of the report, if we turn to volume 1, we can find that at LFB 0001565. And if we could turn to page 4, this is part of the executive summary, Miss Upton, and you can see roughly a third of the way down the heading Next Steps. And the 4th bullet point contains the following recommendation, namely, a register for competent persons to assist those responsible for the fire risk assessment and the prevention and protection measures that fall out of this need to become more accessible, similar to the gas safe register. Now, am I right in understanding that the gas safe register is mandatory?
Yes, I believe it is.
Now, in your second witness statement, which we find at HOM 0005082/14, and at paragraph 51 at the bottom of that page, you were asked whether you'd formed a view about the merits of that proposal, and you said this: I imagine I would have thought that the suggestion to establish a similar profile for fire risk assessors as that enjoyed by gas engineers through the well-established gas safety register would, in principle, have been a helpful means to provide businesses and other responsible persons with an easily recognisable degree of assurance about the competency and experience of those they may consider employing to carry out their fire risk assessment. In binary terms, did you support or not support this proposal?
I suppose I supported the principle that it should be as easily recognisable, that if you were a business looking for a competent fire risk assessor, there was somewhere where you could go that had the kind of profile of the gas safety register. I think I was not necessarily, based on business views, as supportive of that, making that mandatory. And I think you could have had, and I think my expectation was of the Fire Sector Federation was that it would have developed and publicised a scheme for business around these are competent fire assessors and they've been assessed to a common standard, and with these bodies' standards have UCAS accreditation and these have professional standards, and they would have publicised that in the same way. But I think what I wouldn't necessarily have agreed with is that all businesses should have had a requirement to use a fire risk assessor on a register because of the added regulatory burden that would have imposed upon them. And it was quite clear that lots of businesses were doing risk assessments without the need, high quality risk assessments, or had arrangements in place that they were comfortable with to deliver their risk assessments. It just wasn't necessary to be mandatory, but I would have liked something like a Corgi fire safety risk assessor to be, if you're a business looking for help, you could go to a single point of contact.
There's a lot in that answer. First of all, you didn't do anything to discover the views of business in relation to the merits of a Corgi-style scheme for determining the competence of fire risk assessors. Is that right?
No, but we had the evidence from the focus on enforcement review and from the initial evaluation, where it wasn't universal. Businesses weren't screaming out for writing all the time, or it was an issue around the quality, not knowing the quality of a risk assessment.
You mentioned that there were high quality fire risk assessments out there. On what basis did you reach that view?
I suppose because of yes, I don't know. I suppose because the evidence
what basis did you have?
Fires not spreading very far, being very few fires. I suppose the fire safety measures. No, we didn't. You're right. I'm sorry.
There is an element that I don't know what number report this is, which makes recommendations regarding the competency of fire risk assessors. There's an impression, Miss Upton, that you pick and choose what you want from certain reports. You picked upon reports of business lack of enthusiasm for a competency scheme and treat that as compelling evidence not to do anything, and yet the consistent theme of encouragement for there to be a proper scheme for determining the competency of fire risk assessors, you ignore. Why?
Well, I think largely we did want a scheme for competent fire risk assessors and worked, and there was a guide to choosing one, there was an agreed competency standard, there was information available on where to go to get somebody with third-party assurance around their competency. It wasn't a mandatory scheme, but you could find that information. It was such a deregulatory environment that we were in. Businesses were absolutely adamant that they didn't want more regulation, that they wanted...
But I think we've established you did nothing to establish the view of businesses.
No, but through the focus on enforcement review work, BIS did. BIS at the time, I think.
The Department of Business and Industrial Strategy, I think, was one of its titles at one stage.
Yeah.
Okay. So that...
A good point, is it?
I think so.
Right, well, Miss Upton, we've done enough work for the day. We're going to stop there. But I'm going to have to ask you to come back with some more questions tomorrow. I think you were expecting to do that.
I was, yeah.
Yes, right. Well, as I say, we'll stop there. We'll resume, please, at 10 o'clock tomorrow. And again, I have to ask you not to talk to anyone about your evidence or anything relating to it when you're out of the room. All right?
Yes.
Thank you very much. You'd like to go to the usher, please?
Yes.
Thank you, Mr. Kinnear. 10 o'clock tomorrow then.
Thanks, sir.